introduce formally Mr. Dev Kumar Kothari ji.
Good evening, friends. Thank you, President, for giving me an opportunity to introduce C.A. Dev Kumar Kothari ji. Mr. C.A. Dev Kumar Kothari is a qualified chartered accountant and company secretary. His main practice area is providing consultancy service by drafting and or reviewing of draft documents and finalization of accounts, returns, written submission, etc., and appearance before authorities and tribunal, and required as main representative or as guest representative with other professionals. Work from home through ITES, telephones and emails has been practiced by him for long period of time, providing convenient way to clients and concerned accountants, executive professionals and advisors. With a bit hard work and practice, all concerned are able to carry out work very smoothly and conveniently, and generally without need of a personal visit for carrying out his work. Initially, he can preferably be contacted through his email and message. On the contact address and mail address will be shared with on the screen. In past, about 100 detailed thorough-provoking article has been published in professional magazines of Institute, ITR, CTR, Taxman's Magazine, Taxation, etc. However, due to constraint, presently he is mainly contributing article to website www.taxmanagementindia.com, on which there are 879 detailed and thorough-provoking articles are found. Mr. Uma Kothari, his wife, is also qualified CMA, CA and CS. Besides, she is also IBC professional. They both work independently and jointly as per requirement of the assignment. With these words, I welcome Mr. Kothari and hand over this proceeding to him. Thank you, sir.
Good evening for inviting me for this meeting and recalling my earlier contribution to the institute. I am glad that Sri R.R. Modi insisted me to participate in this and to speak on the subjects of Vivad Se Vikas, Vivad Se Viswas, and the new company taxation option. So I had to work hard because I was really not very much inclined to suggest Vivad Se Viswas for the reason that most of our claims are well founded and the department has disallowed claims due to suspicion only. And the main theme and main thing in mind of the for formulation of this scheme is to forcefully collect tax by offering a Samadhan scheme on disputes which have been created by the departmental authorities only due to surmise, conjecture, by ignoring supporting primary and statutory evidences, mainly in respect of share capital, loans, and capital gains, etc., by describing bogus purchase, bogus sale, bogus capital like that, without any valid basis. However, SSCs are fed up with litigation. Therefore, many will go for the Samadhan. So far, this act is concerned and the scheme is concerned, it is half-heartedly prepared. This can be seen from the very name of the act, that is called direct taxes, Vivad Se Samadhan, Vivad Se Viswas, whereas what is covered is only Income Tax Act. Even Wealth Tax Act is not covered. In question answer, in a frequently asked question also, CBDT has said that WT will not be covered. So why the name has been kept as direct tax Vivad Se Samadhan, Viswas? Even in case of income tax disputes, there is not full coverage, like AAR, Settlement Commission are not covered, and 264 petitions where can be filed when time is available is also not covered. Therefore, it is half-hearted approach of the department. And then the drafting is so complicated and complex that it is likely to create more disputes. I have provided written notes reproducing the Act rules and circulars and the provisions with highlights and remarks made by me in one column. I will go by the Act. The Vivad Se Viswas Act 2020. In this first definition is appellant. They are really said to be definitions and subject to contextual requirement. However, in fact, these are definite meaning. The first definition is about appellant. That is, appellant means. Here also we find that there is lacuna in definition, because in case of appeal, an appeal or a person in whose case an appeal or a writ petition or special leave petition has been filed, either by him or by the income tax authority or by both, before an appellate forum. Here, pending references under section 256 are not covered. And even the appeal under section 260 is also not covered. 1 minute. Suddenly my computer crashed, I think. And in main computer, I am unable to work, where I was ready with all documents opened and another computer to hold the meeting. In remarks column, I have written order of AOCIT will ITAT High Court in a VP are covered. Order of High Court in a writ petition is covered, but not order on appeal under section 260A or reference under section 256A are not covered. This is likely to create dispute. Other are the pending matters before DRP, where DRP has not passed any order, or order passed by DRP but not acted on by the AO. That can be covered. In case of 264 petition, as I told earlier, it is only where it is pending that one can go for some settlement by filing a declaration. However, when time is available to file a petition, that case is not covered. In appellate forum, it is right from CIT appeal to Supreme Court, that is covered, but advanced authority for advance ruling is not covered. Declarant will be the person who make a declaration to avail the facility. Disputed income, that has to be computed with reference to disputed tax. That is also a complex situation of computation, and different type of computation might be prepared by different people, applying mind differently. There seems a difficult situation about it. This disputed interest means interest determined in any case under the provisions of the IT Act, which is charged. Such interest is not charged or chargeable on disputed tax. What is charged, what is not charged, and what is chargeable, that has to be determined, and that will pose a difficulty of perfect computation, because different mind can be applied. In case of disputed penalty, again, there is such penalty is not levied or leviable in respect of disputed income or disputed tax. It has to be determined. And the method is difficult. That is provided in rules. However, that is also a difficult situation. Not means clear from doubt. Besides going through the provisions, I also like to discuss the matter relating to decision making, to whether to adopt this process or not. For that is a very crucial thing. Otherwise, the provisions and procedures, we have to go by the system. Through the My Account, the application will have to be uploaded. and it will be examined by the authorities concerned. So that is as per the system. There is not much scope to deviate from that. However, there are difficulties. So my suggestion is that if you want to go for filing a declaration, you prepare a draft, keep it on your website in your account and review it. And once you get the perfect result, which should be there about what is the disputed income, what is tax payable, then it can be uploaded. If there is any difficulty, then a petition or grievances can be submitted to the DG grievances, a technical section of on the website available. From there, I hope it will be clarified. For example, there is no link for 143.1 earlier, but now in FAQ, the CBDT has clarified that certain additions under section 143.1a can be settled. Whether that link is provided or not, that has to be seen. So there may be some practical difficulties in uploading Form 1 and finding exact result, which should be for the amount payable. That may pose some difficulties. So steps should be taken to draft petition and keep it reviewing for the purpose of perfect result. In case of problem, matter may be referred to the authorities concerned. Another aspect for decision is what is the merit of your case. If your case is meritful, then there is no need for settlement. You can continue on contesting the issue before the appellate forum where the matter is pending. Because many of the disputes are based on bias and presumptions of the income tax authorities. They have presumed that there is bogus capital gain, bogus capital contribution, or bogus purchase, bogus sale, on which large demands and disputes are pending. It has been held by Supreme Court in several cases in high courts that unless there is evidence that cash was returned back, there cannot be made any addition. Furthermore, as per Evidence Act, basic primary statutory evidences are to be applied. Verbal evidences of third party cannot be applied. That will amount to only mere suspicion. And based on that, recorded documents cannot be discarded, which the department has done for raising demands due to suspicion only. In such cases, one can contest the matter if the amount is large, and if the amount is less, then it is probably better to avail the samadhan and pay for tax under this scheme, Vivad se Vishwas, and buy peace of mind. It will not be that we are accepting that addition. There are many issues relating to filing, etc. That will be, I think, resolved in course of filing of the documents. And there are FAQs answered, total 95 by the department. That makes many things clear. In fact, when I read the act and rules and made my observations, I found that the answers given by the CBDT are similar to what I had in my mind. Again, coming to the provisions, let us see. There are so many provisions and explanations that make the scheme totally complex and confusing one. Now the time available as per present position is 31st December to file the declaration, and payment can be made by 31st March 2021. The 15 days limitation has been removed, and authorities are also required and requested to issue certificate in due as early as possible so that one can avail the scheme by paying the tax. In this scheme, I found one thing important which can be of use, that you can forego your unabsorbed depreciation and business loss and MAT credit and adjust it against the amount payable on under Vivad se Viswas. So that can be useful where companies are having MAT credit, which is not likely to be adjusted in near future. They can avail. This can be a means of financing that amount payable under declaration. Similarly, in case of losses which are likely to lapse, they can be used to settle the other disputes and finance the amount payable under the declaration. That will be a good opportunity for companies who have suffered losses and depreciation, which is not likely to be set off in near future. That will be a useful for many sick companies who have turned around or will take long time in earning taxable income. They can use their unabsorbed losses, which are likely to lapse, and even otherwise, which may be set off in next 3-4 years, that those can also be used, because today's saving will be more useful for future earning. Similarly, the case of MAT credit, where it is lapsing, it can be used. Cases where there are litigation, where merits are not so strong, they can be settled and must be settled to buy peace of mind and to avoid future uncertainties. Another aspect in respect of decision making will be to consider what is the future of the appellant declarant. Keeping in mind the future, present disputes can be settled or contested based on their present and future likelihood of the state of affairs. That will be a factor to be decided and considered for deciding whether one should go for a Vivad se Viswas settlement or not. Matters where department has gone into appeal, they can be settled at 50% of the tax instead of 100%.
We can't hear.
Sir, you are unmuted yourself. Kothari sir.
I think we can't hear.
Kothari sir, now you are okay.
We have 75% chances of winning at higher forum or in the appeal. In that case, he has to pay full tax, but there are saving on account of interest and penalty, and uncertainty is removed. Peace is bought. However, where the amount is large, it has to be decided vis-a-vis the cost of litigation, probability of winning the case. I recall we had a very tough paper of mathematics and statistics. We learned many topics and many theories. However, sometimes we find that probability theory is useful and that we can apply in various decision making. Other mathematics and statistics, except some relation, correlation theory, etc., others are not used in our profession. But probability theory we can apply while deciding about Vivad se Viswas settlement or any other settlement with the department, and whether to file appeal, whether to contest appeal, whether to buy peace of mind under any other method. That we have to keep into mind. Therefore, in case of loss-making companies and in case of companies having substantial tax credit or losses, this can be a good part in decision making.
Uh,
1 minute.
I request Modi ji to kindly chip in. I just wanted to tell you all our participants ki CA Ram Ratan Modi, our past president, is the moderator of the session. May I request Mr. Ram Ratan Modi to kindly chip in?
Yes, Mr. Modi ji, kindly do it. I am just.
Yeah, thank you, Anup ji. I mean, yeah, I mean, very correct. I mean, Kothari ji have been deliberating on this very important point that wherever we have a losses, I mean, being carried forward. So probably, I mean, probably they are going to be lapsing within say a year or two. Then probably that advantage can be taken off because otherwise they are going to lapse in any case. So he is very rightly said. I mean, in those cases, this VSVS scheme can be availed and these losses will be sort of acting as a financing sort of thing. So that's a very good suggestion by Kothari ji. The only thing is, I will beg to, differ with Kothari ji only in one point. Kothari ji, you will, I think, pardon me for that. I will rather suggest, to buy peace is more important at this point of time, looking at the way this government is fighting all these bogus issues. Though you are very rightly saying that they do not have any merit in making those additions, right? It's based on conjecture, surmises, you are very rightly saying. And you have very rightly quoted such Supreme Court judgment, and that unless and until there is a clear evidence or direct evidence of receiving money back, these additions cannot be sustained. But still, in spite of that, keeping in mind the attitude, which recently the assessees are facing or we the authorized representatives are facing, we are advising our client to go for this scheme and to buy peace forever. This is my personal view, sir. With due respect to you.
That is true. However, we have to see the theory for decision making, the cost of litigation and the amount of tax. If in case of a small assessment, demand 10 lakh or 20 lakh rupees, it is better to settle.
Okay.
But however, where the amount is in crores and merits are good, that must be contested.
Okay.
That is my view.
Okay, sir.
Now, coming to the other provision. Really, I'm sorry, my computer on which I was ready with all files opened and another computer for this meeting, that first computer had just, I think, crashed in. It is not booting. It was having all the files open for my purpose. But again on that another computer I had to do it. I am going
no
to
issue, sir. We are patient. Our members are also patient enough. So please take your time. No issue, sir.
Modi ji, there was a question in the chat box. If you will allow me, then can I ask this question?
Yes, why not, sir?
This is little deviated from the topic. It is, what if the Form 3 has been issued but tax credit is not given? But this is due to error from SSC side as well as from the Income Tax Department side. This is the question from Priyanka Ajit Saria. She has put it in the chat box. If you could take up this question.
Kothari ji, will you be answering this question? The tax credit is not given, because of the error from SSC side as well as from the department side.
That can be rectified, I think, by filing a revised application.
No, revised application means declaration you are referring or what?
Declaration can be revised.
No, sir. Sir, let me, I have a disconnect. Once a Form 3 has been issued by the Income Tax Department, we do not have any options of filing Form 1 and Form 2 again. The course of action, which in my knowledge, please correct me if I am wrong, the course of action from the LCC side is to file a 154 petition before the concerned PCIT, whosoever may be, copy mark to the concerned AO, stating what is the disconnect, what is the difference in the tax arrear and the tax demanded. And then SSC should also follow up with the concerned PCI to get it rectified. Once this Form 3 will be cancelled from the department, then only the new Form 3 will be issued. There is no option of filing again a Form 1 and Form 2 in the revised format once the Form 3 is in place. This is what we have. This is my practical experience so far. So
Besides that, I think one can also lodge grievances through my account in
yes,
respect
sir.
of that
Yes, correct. You are right, sir.
cancellation of that Form 3 and the reconsideration and reissue of Form 3.
Perfectly all right, sir.
That I think that facility must be made available. In this
Yes.
regard, representation went to the CBDT for making certain changes, because there are many difficulties people are facing in filing Form 1 and its processing and ultimate Form 3 and payment. There will be differences and there will be difficulties.
Yeah.
So this has to be sorted out. Regarding filing of declaration particulars to be furnished, the things are clear, except the practical difficulties, and the provisions have to be seen as they are. Even if there is some difficulty, we have to work out the solution. Form 1, Form 2, Form 3, and Form 4. There are some things which are superficial and which were not required and can be avoided, but they are provided. So we have to file them, like withdrawal of appeal. When it is deemed that on settlement that appeal will stand withdrawn, there was no need, but it is provided, so we have to comply with the requirement. Now coming to section 7, no refund of amount paid. Amount paid under this scheme will not be refunded. That is one of things. Suppose there is a mistakenly higher amount has been paid, or then there must be facility to refund it. If for any reason it is found that calculation mistake was there, so excess has been paid, there must be a provision for refund. That is not there. However, tax paid before filing of declaration, if that is in excess, that will be refunded, but without interest. Declarations cannot be filed in respect of such cases where demand tax disputed is 5 crore rupees, more than 5 crore rupees in 1 year. If there are different years, in 1 year there is less disputed tax that can be settled. However, in case of block assessment, 5 crore limit will apply. If there is 5 crore, then it cannot be settled. That is the provision in the Act. In certain cases, there are restrictions where this facility cannot be availed, like some cases under COFEPESA, money, Prevention of Money Laundering Act, and like that. They are applicable in few cases, and I think our audience is not very much interested in these provisions, so that need not be discussed in detail. The board has been given power to issue directions and procedures, laid down procedures and clarifications, and accordingly board has been doing these. But with every clarification, some more confusions are arising. That is the unfortunate aspect of this scheme, because it is very complex and confusing. Power to remove difficulties are provided in section 11. So whatever difficulties we are facing, if we approach through institutes like ACE and our Chartered Accountants Institute, I think government will try to remove those difficulties. There have been some relaxation under the original scheme, by which the dates have been extended for filing of the declaration up to 31st December and payment by 31st March 2021. These are the revised dates, and earlier the period of 15 days from the certification is no longer applicable. This has been by way of amendment. other rules regarding laying down the rules and guidelines issued before both houses of parliament are all standard procedures. But one can find a technical aspect in those also in due course. If there is some lacuna, that can be perhaps a region of litigation again. Now, coming to revocation of this, that is in section. No conceding on issues by declarant, not binding in other proceedings. That is my remark in respect of this aspect, that whether a declaration filed can be used by the department against the SSC in further other years, where there has not been settlement or where similar issue arise in future. That department cannot take. That once you have accepted that long-term capital gains are bogus and you have paid tax, then in next year also it will apply. That cannot be taken by the department as a precedence. That is a safeguard for the future. And for other cases where there is a no settlement. Suppose in 1 year there is a smaller amount, we go for settlement. In another year there is larger amount, we do not go for settlement. We can pursue that other year matter in appeal and contest, and department will not be able to say that in 1 year you have settled it, so it will apply to the other year also and you must pay tax. That they cannot take. That can be contested. However, there is a practical aspect. Even in course of appeal hearing or assessment hearing, authorities say that such and such people have paid tax under earlier schemes. They have surrendered this income in due course, in the course of survey. So they are not full. Authorities say like that. But that is not binding on SSC, or department should not take such instance. However, while threatening the people to collect more tax, these are armed practices adopted by the authorities also. They give examples of others who have paid tax and ask why you are not paying. Coming to section 4, filing of declaration and particulars to be furnished. That is under rule 3, form 1. Then upon filing, withdrawal of appeal is deemed. That I had discussed. That appeal is deemed to be withdrawn. So there should not be further need to file a declaration in this regard and to file evidence in this regard. And I think this can be amended by way of removal of difficulties in implementation of the Act. The procedure is not required as discussed in earlier para 3. That is in respect of section 4. I am speaking about section 4, subsection 2 and 3, about the declaration and the undertaking. Similar is case where the declarant has initiated any proceeding for arbitration, conciliation, or mediation. Or is undertaking. Procedure of as per subsection 6, the declaration under subsection 1 shall be presumed to never have been made if any material particular furnished in the declaration at any stage, or the declarant violates any of the conditions referred to in this act. The declarant acts in any manner which is not in accordance with the undertaking given by him under subsection 5. My remarks in this is that invalidation of declaration and certificate the scope seems to be unduly wide and it is not in tune with Vivad se Viswas or even with this Vivad se Nijat. This can create lot of litigation due to doubts, surmises, conjecture of tax authorities, due to which most of the Vivad arises. Most of Vivad, the disputes are because of the high-handedness of the tax authorities. So this scope of declaration being denied after accepting due to any subsequent finding or observations of authorities is very wide and it should be restricted. Once a declaration is accepted, that must be final for all times. Whatever inquiry is to be made by the authorities, that must be made beforehand, that whether the declaration is acceptable or not. Once accepted, it must be final. So the presumption that declaration will be presumed never to have been made if these conditions apply, this provision is very serious and it is not in tune with the object of the scheme. This provision really should be removed. Subsection 7 is no appellate forum or arbitrator, conciliator or mediator shall proceed to decide any issue relating to tax arrears mentioned in the declaration in respect of which an order has been made under subsection 1 of section 5 by the designated authority or the payment of sum determined under that. That is obvious that once a matter is settled, there is no need of hearing. This provision has been made. It seems to be superficial. Immunity from initiation of proceedings in respect of offences and imposition of penalty in certain cases. This is section 6. Subject to the provisions of section 5, this is again subject to something else. The designated authority shall not institute any proceedings in respect of an offence or impose or levy any penalty or charge any interest under the Income Tax Act in respect of area. Here the word used is that designated authority shall not institute. What about other authorities? Whether other authorities can continue or impose these things like penalty or other charges or interest on SSE, even though he has made a declaration and paid the tax. So this clause also is not well drafted. Why the word only designated authority has been used? That is a omission. There appears to be omission. There, any authority, any income tax authority should not have any authority and should not institute any proceeding in respect of an offence or impose or levy any penalty or charge any interest under the Income Tax Act in respect of that tax area which has been settled. The use of words designated authority is likely to give provide a scope of litigation and harassment by other authorities. No refund of amount paid. Any amount paid in pursuance of a declaration made under section 4 shall not be refundable under any circumstances. That also require removal of difficulties. Refund of excess amount paid beforehand and without interest. Tax paid beforehand, that will be allowed to be refunded, but without interest. Scope of benefit of any declaration is restricted to only matters covered under declaration. Section 8, as per section 8, the benefit is restricted to the declaration. That is obvious. Only the dispute which we have settled, for that the benefit will be available. Making such provision again make the issue complex. This is not required, but a provision has been made. Because suppose if there are two demands in 2 years, one is settled, one is not settled, the other will continue. So there is no need of this sort of provision, but they have been inserted in the Act, and that will provide a scope of litigation. Act. If prosecution has been instituted under specified enactments, the person cannot make a declaration. Person against whom specified prosecution has been instituted or a person who has been convicted cannot make declaration. However, other persons may be associated with that, they can make declaration. Notified persons under specified act, that is offenses relating to Transaction in Securities Act, they cannot make a declaration. This is very old matter, and how many people will be there, God knows, but this provision has been made. Maybe it is of no use, but the provision is there. Now coming to rules, Vivad se Viswas rules. I had provided a write-up with highlights and some of my observations on that also. The first section is definition. Dispute. Class B is dispute, means here my observation is appeals filed or to be filed for which time is available on specified date, both are covered. That is clear by board also, and there is no doubt about it. That if order is passed and time is available for filing of appeal, even after that can be settled. WP only file cases will be filed both covered. In case of writ petition, only where writ petition has been filed are covered, and not where writ petition can be filed. That is not covered. Eligible search cases. That is, search cases tax not exceeding rupees 5 crore are eligible. 5 crore applies to each year or each assessment. In case of block assessment also, 5 crore limitation will apply. Forms prescribed are form 1 to 5. So far, no other form is prescribed. Form of declaration, form 1, form 2 undertaking, signature and verification is provided in rule 3. Acknowledgement under sub rule 434. Certificate is in form 3. Now, in the forms, what are difficulties that I have not studied? There may be difficulties in filling up the forms also and ascertaining the contents which are required to be furnished in each of the form. That matter I have to study. It is not yet undertaken by me. Manner of furnishing electronically under digital signature. If ITR is compulsorily by this method, means by digital signature, otherwise EVC, verification through EVC can be adopted. This will be all online, so there is not problem. Laying down of procedures, forms and standards. The DGI, principal DGI system or the DGI system shall provide about procedures, formats and standards. So I think if difficulties are arising in filling up the form, ascertaining figures, and there are difficulties in reconciling the amount payable, we can approach to the principal DGI system or DGI system through my account. If there is a separate link for Vivad Viswas or otherwise in general link for the grievances provided in my account. I hope that should work, but time available is short. Manner of computing disputed tax in cases where loss or unabsorbed depreciation is reduced. This is provided under Rule 9. This is important, but this involves computational aspect. So this has to be studied with the practical example of cases of losses that is nowadays available in the return form of earlier year and tax audit report. So it is not difficult. So what are the chances of absorbing the losses? That can be a serious exercise. Time available is short, so that has to be done fast. Manner of computing this in case where loss or unabsorbed depreciation is reduced and met credit. This I discussed. These are provided in the rules. So for this, practical computations have to be made for any of the SSC who want to make a declaration and want to get some benefit of losses which are carried forward. So far depreciation is concerned, as per Income Tax Act, there is no concept of unabsorbed depreciation. The depreciation which has not been allowed, that form part of the current depreciation. However, as a matter of practice in ITR and tax audit report and other details, year-wise depreciation is worked out. All depreciation as per section 32 becomes current depreciation. So depreciation will not lapse. Losses can be used for declaration. Depreciation can be used where there are huge amounts of depreciation available and there is little chance of recovery. That can also be used. It should not be considered that a certain part of depreciation is lapsing. It will lapse in short period of time of say 1 or 2 years. So that aspect has to be considered in view of that. Rule 11 is about manner of computing disputed tax in certain cases where the dispute includes issues covered in favor of declarant. The disputed tax in respect of such issues shall be the amount which bears to the tax, including surcharge and cess payable on all the issues in dispute, the same proportion as the disputed income in relation to issue covered in favor to the disputed income in relation to all issues in dispute. That is a proportionate computation will be there. These are the computational aspects. I will not, that has to be go into it because they have to be seen with the example or exact figure of particular case. Computation provisions are there. How certain amounts will be ascertained, that is provided in the rules. Now there has been circulars. There are three circulars issued. In first, there are 1 to 55 cases, another 56 to 95 questions frequently asked, they have been answered. I had provided copy of them also with highlights provided thereon. I think it does not require much discussion and they can be studied, and in case of need in future, again, meeting can be held. So let us prepare for filing declarations. Before that, making decision whether the client should file declaration to avail the benefit provided under this scheme for the settlement of disputes as well as for gaining out of unabsorbed depreciation and business losses. In case in past there were losses and now companies earning good profit and those can be used. So that is to be decided in respect of each of SSC who want to use them. These are my observations on frequently asked questions. If you want, I can deliberate, but I think those are matters, lengthy matters that require to be studied personally and then can be discussed.
Kothari ji, just a humble request. I mean, we have a lot of questions in the chat box also. I mean, broadly, you have discussed the entire scheme. You have also discussed the rules and the, circulars. So whatever the questions are there in the chat box, can you take up the questions from the chat box? Couple of queries are there in the chat box. Are you able to see the chat box, sir? Queries in the chat box.
I am trying to find it.
Is there in the bottom, or should I read it for you? I mean,
I just I
you
can
have to click on the chat. You have to click on the chat, and then probably you will find all the questions.
Modi sir, if you can read it, so it will be made quickly, I believe.
Just Kothari ji, मैं read कर लूँ? I mean,
read कर लीजिए.
huh? Okay.
हाँ, please read.
Okay. Okay. Then let me start from the beginning. 1 minute. I'll start from the last, because that is appearing. Somebody was asking, I mean, regarding the withdrawal from CIT appeal or from the IT-80. So what that letter should be, and what should one do if CIT appeal is not issuing the withdrawal approval letter? I mean, there was a question sometime in the middle. So what will be your answer? If suppose CIT appeal, I mean, I made a request that I have opted for this scheme, I filed the declaration. Along with the Form 3, we have to file this withdrawal approval letter, sort of. So how do we get that letter if CIT appeal is delaying the thing? Or we are not getting it from IT-80?
Hello. Huh. We can file letter through email as well as physically. And once there is no rejection of that, that must be assumed that it has been taken note of by the CIT appeal. And withdrawal letter with the acknowledgement duly received by the CIT appeal should be evident. And it will be better if we make request to provide certain guidelines for draft of form for request for withdrawal as well as confirmation of withdrawal by the concerned authority.
Sir, do you mean to say the SSC should wait, the applicant should wait for a couple of days, say minimum period of 7 days for acknowledgement of that appeal withdrawal letter, or instantly I have applied to CIT appeals through mail for appeal withdrawal letter, and tomorrow itself I can file Form 4. There should be a time gap of 7 days, or should I file instantly? My question is this.
There is no need. There is.
Beg your pardon, sir?
Sir, your sound is not clear. Can you come nearer to the mic, sir?
Yes.
Sir, we can't hear you.
Yes, Modi. Thing is that we file a letter before the concerned authority, say CIT appeal or tribunal, and evidence that should be sufficient. If the department want to confirm, they can confirm from the CIT appeal.
No, the only thing is, sir, the public, I mean, our members are in doubt because it is specifically mentioned that along with the Form 3, I mean, while you will be paying the taxes, you will have to attach the proof of withdrawal. I mean, though you are very correctly saying that it is deemed to have been withdrawn, but then what was the necessity of putting such a condition that the evidence has to be attached? So that is where our members are really confused, sir. So we were asking these questions only. So as per you, you are saying that since we have made a request for the withdrawal of the appeal in view of the application, in view of the declaration made by us, so as per you, this itself will be sufficient. Rather, probably I will, I mean, if I can advise with your permission, that suppose after 6 or 7 days, as our president sir is suggesting, we again make a reminder sort of thing to the learned CIT appeal. And even if there is no response from the learned CIT appeal, then probably take it that we presume that your, this thing is there, and then we file the same before that. I mean, is it okay, or we should not do anything whatsoever?
Hello.
Hello. Hi, sir, you have muted yourself.
I'm just. We can, withdrawal is our decision, and that withdrawal is in view of the declaration filed.
Yeah.
So once we decide to withdraw and convey this decision to the CIT appeal and obtain an acknowledgement, that should be sufficient. There should really not be a requirement to have a approval from the CIT appeal. Because
only one thing, Kothari ji, only one thing, I mean, withdrawal is a mandatory thing. I mean, we do not have any option. Once we opt for declaration, then withdrawal is mandatory. We have to withdraw all disputes.
We withdraw, we write to the concerned authority, appellate forum, that we are withdrawing it.
Sushil Bhaiya kuch wanted to say something. Sushil Pansuka ji, you want to add something?
Just I wanted to
Sushil ji,
add,
please. Yes.
just I wanted to add this on this discussion that practically what is being happened that you simply send a mail that I am withdrawing this appeal. I have availed the VS Vestic, that is enough. Because the languages which have been used, that there is a dichotomy, no doubt. But what is the practical that you should just give a letter and that I have withdrawn the appeal since I have availed the VS Vestic, that is sufficient. That
Sushil-
proof you attach with this letter.
Sushil Bhai, you mean to say I'll send a mail to the concerned CIT today. Today
Yeah.
itself I can file Form 4 in the evening?
Yeah, correct. Yeah, you just take the printout of the mail and you attach with that. Yeah.
Okay. Sushil Bhai, what if the appeal is being done by the department? This was a question in the chat box. If the appeal is being preferred by the revenue before say ITAT or before say High Court, then how there is no question of withdrawal from the SSC side. So what will be the applicability of withdrawal things over here?
No, they will also do the same thing. That will be automatic since there is a provision that will be deemed to be withdrawal. If you don't attach the proof also, then it will deem to be withdrawal.
Okay.
There is no worry on that point.
Even if the appeal is filed from the revenue side.
Yeah.
But yeah, my only, doubt here is, suppose the matter is pending before the High Court, appeal is pending before the High Court. In that situation, can that risk be taken that, without the approval letter of the High Court?
No, there is no approval required at all, anywhere.
No, the only thing is
you have to attach the proof of the withdrawal, that you have withdrawn the appeal.
Okay, their approval is not required, where they have consented for the withdrawal.
Approval is not required.
Okay.
Then that scheme will fail and it will come.
Okay.
No, but there is no proof for withdrawal of appeal from the High Court. And unfortunately, in this VSV, any taxes paid cannot be refunded. On technical grounds, if for at all it is rejected, then the whole taxpayer money is gone. I think a representation is required to the CBDT to issue necessary, draft forms for application as well as issue by the appellate authorities that yes, it has been withdrawn. That should be it.
Pramod Himatsingka ji, do you have any independent view on this? What has been discussed in the forum? Pramod Himatsingka ji, do you have any independent view?
Yeah. So far, appeal withdrawal is concerned, we are discussing this. I fully endorse the view of this Sushil ji. Only intimation regarding the withdrawal of the appeal before the ITAT and the CAT appeal is only needed. It does not require any approval, and we don't have to wait 7 days or 10 days as we were discussing. We don't have to wait. Only according to me, the High Court and Supreme Court, the leave of the court is needed according to me. Just making an application, I think is not sufficient. Up to tribunal, it is a deemed withdrawal, no doubt. But High Court and Supreme Court provision is differently worded. According to me, now I have to revisit the provision, but according to me, High Court and Supreme Court, the wordings are differently worded. I think you have to make an application and the withdrawal permission is needed, according to me.
What about appeals filed by the revenue in the High Court?
Right. So far, you see, appeal filed by the revenue, we were discussing about the tribunal also, the appeal filed by the revenue. I think we should approach to the assessing officers. Okay, sir, I have already received the form number 3. Kindly withdraw your appeal before because that is not my appeal. I cannot file the withdrawal letter. And the form 4 is requiring the proof of withdrawal. Since it is not my appeal, so I cannot file. But probably, since it is a departmental appeal, if you upload the form 4, this appeal withdrawal proof may not be needed. I have not tried, because whatever I am opting, this all SEC appeals are there. Since if you file the appeal form number 1, you have to write, is it your SEC appeal or departmental appeal? If it is a departmental appeal, then how you can file the withdrawal? You cannot. That we have to check. But the point is, if anybody has any problem, they can approach Sangai-ji, me also. We'll see to it how it is to be done. But I have not applied my mind. So far, revenue appeal is filed. But I don't think there will be any hanky-panky on this point.
I think
Thank you.
Jinesh, Pramodji, Mr. Jinesh Jain was asking a very pertinent question. That suppose you have withdrawn, it's a compulsory mandatory sort of thing that you have to withdraw your appeal if you have filed an appeal. SSC has filed an appeal. Now, you have withdrawn your appeal. Now, by any chance, if your declaration is not accepted, by any chance, it might be 1 out of 100, right? If any chance, then whether your appeal will be restored or, you are fallen in soup.
Yes,
you
yes,
have gone-
Modi ji,
Yeah.
in FAQ it has been written that if Form 3 is rejected, your SWAS scheme is rejected, then appeal will be automatically reinstituted. You need not make an application.
Okay.
That saving clause is also in the act also. That saving clause is also there. You don't have to worry. But according to me, if you have been issued form number 3, there no cause of worry.
Okay. So somebody is asking, Anuj, there are other questions in the chat box. Have you spotted? Can you raise those questions? So we have three learned experts here. Kothari ji, our learned speaker, then the Pransuga ji and Pramod ji is also here. So we can have the advantage in the larger interest of our members to have the opinion of all three esteemed members, speakers.
Thank you, Modi ji. Kothari ji,
one
this
speaker
question
and the two learned participants.
Kothari ji, this question is to you. This is regarding FAQ, which is being issued recently on 4th of December. FAQ number 67. I have put it in chat box, the question as well as the answer. Whether in cases where the appellate authority has quashed the prosecution complaint or ruled in favor of the taxpayer and no further appeal is filed by the department on or before filing of declaration are eligible. This was the question, put it in the FAQ, question number 67, FAQ dated 4th of December 2020. And the answer given by the board, yes, such cases are eligible if the time limit for filing appeal by the department has expired and the department has not filed appeal with or without condonation of application. Let me just tell you the brief of this question, the background of this question. There are cases where in the case of, I just straight come to the topic. In the case of penny stock cases, many of the SSC has won the appeal before first appellate authority or in the second appellate authority, either before the CIT appeal or before the ITAT Kolkata. Now, department has not preferred any second appeal, either ITAT or High Court Kolkata. So this was the clarification being put in by CBDT. The SSC still can opt for the scheme by paying 50% of the taxes. Whether we can understood, whether whatever I understood is correct or there is some problem in my understanding. I wanted to throw light on this particular question number 67 of FAQ dated 4th of December 2020.
Once the prosecution is quashed.
Kothari ji, I hope you are there, no?
Hello.
Yes, sir.
That is question number 67 is whether in case where the appellate authority is quashed the prosecution complaint or ruled in favor of the taxpayer, then it can be filed.
In my opinion, it cannot be filed for simple reason. The whole premise of the scheme is the appeal should be pending or the time allowed in normal circumstances has not expired. Now, if we take the other way, then the same thing SSC can say that yes, we can apply for continuation of delay and we can file an appeal. To my mind,
pendency of appeal or filing of appeal is required, and prosecution is another aspect.
No, but his question was not prosecution. I think it was regarding filing of appeal, where the appeal has not been filed, but assessee wants to go for the scheme.
Correct.
In that case, to my mind, I don't think the assessee can go, because if the time has expired, or if the appeal is not filed by the revenue authorities within the time, then there is no question of going into the scheme. They cannot go, because the whole premise of the scheme is that the appeal should be pending, or you have a chance to file the appeal, not with the condonation, but under normal circumstances.
There must be dispute. If appeal has not been filed by the department and time limit for filing appeal is lapsed, then there is it
No,
needs
no.
to be settled.
Sir, I have a different view. Kothari ji,
Modi ji,
Kothari ji and
I
Dinesh ji,
also
I
want
have
to
a different view with due respect.
Yeah.
I have a different view because it has been there not only in income taxes everywhere, and it's a proven fact that because of the bureaucratic setup, because of the executive setup of the department or the government structure is such that there are often large number of delays in filing appeals by the government department, whether it's income tax or whether it's any other tax, any other matter. And the Supreme Court has very categorically said in one of the judgment that since we all know that this procedural time is always taken by the government, so the delays should invariably be granted. It's a sort of that thing, right? So that is why this language is that the department can always come out. Even in department cases, the delays of 100 days, 200 days, 500 days are even condoned.
Correct.
So
Correct.
that is the view of the Supreme Court, because they understand the bureaucracy.
Susilbhai, your opinion, please.
Yeah,
What
Modi
is
ji,
Susilbhai's opinion?
what you are saying is correct from the judicial point of view. Apart from that, in the FAQ, there is one question that whether appeal time has expired and there is time barred appeal, whether that with condition appeal has been, condition application has been filed, whether they can avail this scheme or not. In answer, it has been said that even if the appeal time has been expired and then assessee has made the appeal, along with the condemnation letter, even before till the date of the circular, that is 4th December, then in that case he can avail the scheme provided the appeal is accepted by the
Revenue.
CIT appeal or ITAT. So what you have to do to see that you file the appeal before the date of the circular, if you have not done, if you could have done, then you just simply approach the CIT appeal and ITAT that you please admit the appeal, then you can avail this scheme. So that 31st January will be deemed to be the pending. Appeal will be deemed to be pending on 31st January.
31st January. Okay.
Yeah, that liberal approach has been taken by the CBDT on this aspect.
So liberal approach have been taken, Sushil Bhaiya, but what do you think the approach of the CIT appeal? Suppose the CIT appeal is adamant, no, I will not admit your appeal. I mean, I will not condone the delay.
Then,
so what remedy do the appellant have?
Only you can approach the higher authority.
Okay.
Then there is no, that is what is there in the FAQ I have told.
Right, sir. Right, Bhaiya.
Modi
So,
Bhaiya, there is another question in the chat box by CA Sagar Jain. He has also asked a very pertinent question. In the case of an appellant company got merged, the appellant company got merged, and how to file declaration with regard to, and who will file the declaration and whose DSC will be used. Say, for example, A has been merged with B. There was an appeal since the order was in favor of the B. Who will file the declaration and whose DSC will be used? Sagarji, are you there? Sagarji, will you kindly unmute yourself and ask the question? Is it your question?
Yes.
Sagarda?
Yes.
Sagarda, is it your question?
Yeah, Anupji, you have rightly pointed out the question.
Okay.
So Kothari ji, what is your view? I mean, Mr. Sagar Jain have raised this question that company A has merged with company B. So A is no more existing. PAN number problem.
Company which is in existence, that company will file.
Okay. So, but okay.
If it is not in existence, that cannot be made a party. That cannot make an application.
So there was a query sometime back in one of the seminar that company A got merged with company B, but somehow a demand was raised on the company A. I mean, though it is wrong, but then demand was raised in the company A subsequent to the merger, and every proper intimation was given to the department. Now, in this case, since the demand is there on A, if the company B is making an application under VSBS Act, then how the things will match? I mean, how the things will be correlated? Because demand is standing in the name of A. Now the application is made by company B. Now how the things will work out here?
Or
Modi ji,
more so,
appeal-
more so,
appeal is
15%
also
of the
filed-
15% of
appeal is
demand will also be paid by B only. 15% of the outstanding demand is paid by B only.
B
So
only.
the demand is standing in the name of A. You rightly pointed out, Modi ji. The demand is standing in the name of A. Appeal has been filed by company B. So VSB will file by company B, but demand will never be vacated from company A, because demand is still in the name of company A, which is merged with company B.
All demands in name of company are now demands on company B after merger. That is a consequence. I think recently Supreme Court judgment has also been rendered that in case of non-existing company, if a notice is issued or order is made, that cannot be worked upon.
Okay. So you
the
mean to say that the declaration, Kothari ji, you mean to say the declaration filed by B will be valid and the department will be issuing them Form 3, I mean, to company B itself?
It must be stated that this was the A was independent company. Now it is part of our company after this.
But there is no question of stating any fact. The form is so mechanized, either you click or you don't click. I mean, there is no way to write anything. So that is the biggest problem.
These are difficulties. For that, we must approach.
Pramod
Okay.
Bhaiya, do you have any say on this?
No, I have not applied my mind on this type of question. I have to rethink from that line. I have not at all applied my. I have not thought of. That is why I am attached over here.
Now, Sushil Bhaiya, can you give any?
Sylvia, can you throw some light?
You see, these are the technical things. What is law we can discuss. Law is that only new entity can file the Vyas Vishwas scheme. And who has paid the tax, who has filed the return, those are the technical things department has to clear over some matter, has to approach the department. How the form-
Can I intervene, Sushil here?
Yeah.
So what happened in similar case has happened with a client of mine. I have filed an application under section 154 for revision of the demand in the name of the merged entity.
Yeah.
I have been told that next week I'll get the order, and on the
Yeah.
basis of that I can file my application.
Yeah, that's very good. So
That's
what
good.
is law? Law I have told that.
Ajay ji, would you please come again? Ajay ji, would you please come again little slowly? Ajay ji?
Yeah, what happened was that company A got amalgamated into company B,
Right,
and company is no more in existence, but the demand happened in the name of company A.
right.
But we had filed an appeal in company B. So, in order to participate in Vivad Se Vishwas, I must have both the demand and the appeal in the same name. So, I had approached the CID sir. He said, you file an application number 54. I'll issue a direction that the demand will get converted into company B on account of mitigating circumstances. So, I filed an application with them that as per material on record, the demand should be in company B because company A does not exist.
That is the
And they
correct
have told me next week I'll get the order of 154.
Okay, thank
that
you
is the
very
correct
much.
process. That is the correct process. You have done.
Anup,
Yes,
I
Bhaiya.
want to say something. Can I say?
Yes, Bhaiya, please.
You see, just coming in my mind, since the appeal has been filed by A Private Limited, A Private Limited, no
Appeal has
more.
been filed by B.
You see, appeal has been filed by B.
Yes.
Yeah.
No, I think the question was that
Filed by A.
the demand was raised on A. Subsequently, it is merged with B.
Okay.
Was merged with B. Okay, and B may have filed the appeal, may have, but the point is the demand is raised on A. So, according to me, since the demand is showing in the A portal, so actually, if digital signature is available with us, whoever paying the amount, it is immaterial. But the point is, in the PAN number of the A should be settled. So, whether I am right or wrong, I do not know. But according to me, A should file the declaration with under their digital signature. And if the form number 3 is issued, then you pay the amount by the B. Who is paying it is immaterial. Government is concerned with the challan. If that settles, I think problem will not be there. But according to me, B unlikely to avail this scheme, according to me.
No,
This is
but
a practical, I'm just thinking. I don't know, I have right or wrong. Sushil can say, throw some light.
in a appeal, A has not filed any appeal. So in the name of A, you cannot file form number 1. There is no appeal pending in its name.
You see, the order has been passed on the A. Order has been passed on the A.
Correct.
If the order is passed on the A, I think appeal must have been filed by the A itself. Must have been. Or asked by, you can say it by. But the point is, ultimately, you are using the PAN number of A while filing the appeal.
See, what happens, I tell you, that in these cases where amalgamation takes place, okay, and whether matter is litigation in tribunal or CIT appeal, then the litigant companies, suppose is in this example company A or company B. B company is a new company. B company approaches the judicial authority that this company is now the new company. This company has merged. So on record, this company should be converted in this research that is done by the members of the CIT appeal. So that should be done before filing the appeal. Before filing the appeal or filing the Vivad Se Vishwas scheme. And what Ajay Bota has said that regarding 154, that is also correct procedure. Demand is raised, converted into B, then we can file the Vivad Se Vishwas. There is no dispute on it.
Over to you, Modi ji.
Yeah, I don't think there are any other questions in the chat box.
So I have one question.
Sir, please, sir, please.
Yes,
Yeah. For deliberations by all, that suppose a SAC has filed the appeal before the ITAT, okay, and this matter has not come up for hearing, it will come up hearing in January 1st week or 2nd week, okay, and 31st December is the last date of the Vivad Se Vishwas scheme. So before 31st, what it is suggested that you file the form 1 number 1 and 2 on 31st December, okay, and then you wait for your appeal on 2nd week of January or 1st week of January, and in the hearing, if I win, then I don't pay, then appeal will be null and void. This scheme application will be null and void. Or if I lose, then I can always pay the tax and forget form number 3 and all that. Whether this approach is correct or there is some fallacy or there's some misrepresentation of fact.
But yeah, there can be third option also. Suppose if I win and there is a chances that the department will go in higher appeal in high court, I can pay 50% of the tax also. There are 3 options. I mean, you have given 2 options. I will rather put 3 options.
No. Your third option will work not now because date is getting time barred on 31st December.
Right.
Okay. Yeah, date is. So since I have, I have filled up the form with 100% tax.
You have to fill up the form by 31st December.
Okay.
So what it is suggested that by 31st December you make an application, wait for the result. Hello.
Yeah.
Wait for the result. If result is favorable to me, then always I can opt not to pay any tax on issuance of form 3, or I will wait till issuance of form 3, then I will not pay any tax.
कोठारी जी आपका क्या व्यू है बताइए सर?
Correct approach.
Both
Is it
options
correct?
can be exercised
Yeah.
uh,
Pardon?
to enjoy the benefit of the order which is in favor.
Yeah.
Need not to pay under Samadhan. Because you have won the case, the demand will be
that I also thought. But my worry is that while filing the form 1 and 2, in form number 2 there is declaration that I will not pursue any remedy. Hello. I am giving the commitment. I am giving the commitment that I will not pursue any remedy. So again, on 1st week of January, I am pursuing the remedy. I am appearing before the tribunal. So whether that will not be in misrepresentation of fact, later on department can go to with the order with the tribunal to recall the order by filing an MA. Then where I will be?
a false statement.
That is my thinking.
Suppose if you
We need a foolproof system.
if you win the case in tribunal, still you
Yeah.
can go for settlement. That
No. If I opt for settlement, there is no question. If I win the tribunal, I will go for the scheme.
For the
But I think Kothari ji, Sushil Bhaiya is very right. Since I made a declaration that I will not pursue any remedy, and fact is that I am acting against my own declaration. And after 31st of December, I am still pursuing with the tribunal hearing. When the date is coming up for hearing, I am appearing there. And my authorized representative is arguing the case. Is it not a case of a false declaration?
As
Now
on
you,
the
you wanted
declaration,
to have the cake and eat it too.
as on
Yeah.
the date of filing a declaration, it is not false because till that date you have not pursued that appeal. Subsequently, due to change in mind,
No,
opinion,
that declaration is that I am waiving my all right to pursue any remedy, any other law, any other law, no, in any law,
Yes.
especially
In
remedy.
that refers to the future tense, Kothari ji. So
Yeah.
in future, I will not pursue any remedy.
I
That is
waive
very
my
clear.
right.
Right. So, Kothari ji, I think that will be.
Sushil, according to me,
I will have
if,
to check.
before filing application, whatever you do, it is permissible. Once you file the declaration, you cannot pursue the matter. You cannot. Even you cannot appear before the appellate authority once you file the application. You have to just write them. Say, I have availed the BSBA, and my appeal should be kept pending.
Now, Pramod ji, suppose in that case, I have filed a letter with ITAT that appeal should be kept pending, but somehow by ignorance, that letter did not come up before the bench and the matter is heard ex parte. And in the ex parte judgment also goes in my favor. Then what will happen?
Yeah, correct.
And there is no false declaration.
And there is no false declaration. Then
Correct,
in that
correct.
case, what will happen, Pramod ji?
And there is-
That is not the first, you see, that is not the first declaration. But it is up to you. Don't pay the amount. You don't pay, if you have won the appeal, don't pay the amount by 31st March. Your application or the form number 1 will collapse automatically.
Yes. That
If
is
you are happy with that, okay. If you are not happy with that, pay the amount, buy the piece.
Okay.
It is up to you.
Right, Pramod ji.
correct.
I think we have the fantastic deliberation on this VSBS scheme, Anup ji.
Modi bhai, there is a question from Mr. Ashok Kumar Sureka. If you can allow me, then I can.
Oh, yeah,
unmute
yeah,
him.
yes, sir. Yes. We are here for the members only, sir.
Mr.
We have to, yeah.
Sureka ji, could you please unmute yourself?
एक मिनट है, सुरेखा जी का उस दिन एक कुछ कहना था, मैं सुरेखा जी को मैं बोल देना चाहता हूँ। वो प्रोबेबली क्वेश्चन कर रहे थे हाई कोर्ट के बारे में। सुरेखा जी, उसमें मैं उस दिन बोलना भूल गया। एक प्रॉब्लम और आएगी हाई कोर्ट में, यदि आप फाइल कर भी दिए कि अपील डेट हैज नॉट एक्सपायर्ड, उस कॉलम को चूज करके अपील फाइल कर भी दिए, अल्टीमेटली यदि अपील फाइल आज तक नहीं हुआ है और आपको फॉर्म नंबर 4 अपलोड करने में आपको प्रूफ देना पड़ेगा, तो प्रूफ कहां से लाएंगे आप प्रूफ नहीं लाएंगे तो आपका फॉर्म नंबर 4 अपलोड नहीं होगा। तो अब जब डिपार्टमेंट अपील ही नहीं फाइल किया हाई कोर्ट में और आपका फॉर्म नंबर 3 आ गया और आपको फॉर्म नंबर 4 अपलोड करना है, तो उस दिन कहां से लाएंगे? वो टेक्निकल प्रॉब्लम है, ये दिमाग में रखना पड़ेगा अपने को।
सर अभी जो क्वेश्चन नंबर 67
बोले क्या बोलना चाह रहे हैं?
अभी जो क्लैरिफिकेशन अनूप जी ने क्वेश्चन रेज किया था कि क्वेश्चन नंबर क्लैरिफिकेशन नंबर 67 है, दैट टेक्स केयर ऑफ दिस कि इवन द डिपार्टमेंट हैज नॉट फाइल्ड अपील एंड टाइम टू फाइल द अपील हैज आल्सो एक्सपायर्ड। वो नया क्लैरिफिकेशन में इंक्लूडेड है। क्लैरिफिकेशन नंबर 67 अगर आप देखें अनूप जी ने रेज किया वो रह गया। हाँ, तो उसमें ये प्रोविजन है if the department has not filed appeal and the time to file the appeal has expired, ये पहले के clarification में provision नहीं था। This concept has come for the first time that the department has not filed appeal and the time to file the appeal has expired. This is a new concept which has come up.
सुरेखा जी,
हाँ सर,
सुरेखा जी, इस क्वेश्चन को आप 31st कट ऑफ डेट के संदर्भ में सोचने की चेष्टा कीजिए। पहले आप 31 जनवरी में आप आइए। 31 जनवरी को आपका अपील फाइल का डेट एक्सपायर नहीं हुआ।
मेरा नहीं, डिपार्टमेंट को
बात कर, जनरल बात कर रहा हूं मैं, जनरल बात कर रहा हूं।
अपने जनरल बात कर सके, स्पेसिफिक बात कीजिए। आई वन इन ITAT and department has not filed any appeal so far, but they will file appeal in future because of the monetary limit in penny stock cases. So वो प्रॉब्लम फ्यूचर में आएगी, उसको कैन वी टेक केयर ऑफ दिस somewhere or other by filing common.
वही तो मैं बोल रहा हूँ ना,
clarification number 67 has made our task
नहीं
easier.
नहीं, क्लैरिफिकेशन 67 जो है,
हाँ.
देखिए इस चीज को मैं उस एंगल से देख रहा हूँ. यदि ये सिचुएशन आपका 31 जनवरी के पहले आप जीत गए, देखिए पहले तो मैं बता दूं 11 अगस्त 2019 के बाद में ट्रिब्यूनल का कोई ऑर्डर नहीं आया.
हाँ ठीक है, उसके पहले का ऑर्डर है, उसके पहले
ठीक है, पहले का ऑर्डर वो होना ही है, पहले का ऑर्डर.
हाँ.
ठीक है, तो उसका ऊपर नहीं आया. आपको आना पड़ेगा 31 जनवरी 2020 को. अपील फाइलिंग का डेट एक्सपायर नहीं किया, आप उसको चूज कर लिए, फेयर एनफ, नो प्रॉब्लम, मूव अहेड. अब फॉर्म 3 आ गया, आपने पेमेंट कर दी 50%. अब आपको फॉर्म नंबर 4 अपलोड करना है. फॉर्म नंबर 4 में आपको पेमेंट डिटेल देना है, अपील फाइलिंग विड्रॉल प्रूफ देना है. कहां से लाएंगे? अपील फाइल नहीं हुआ डिपार्टमेंट का, तो कहां से लाएंगे? तब आप क्या करेंगे ये बताइए. तो आपको उस संदर्भ में सोचना पड़ेगा. इफ यू मूव अहेड विद द 50% पेमेंट, उस सिचुएशन में आप सोचना पड़ेगा. 31 जनवरी की डेट में आपका अपील फाइल नहीं था, वो आप चूज कर लिया आपने, नो प्रॉब्लम. आप आगे का सोचिए.
नहीं, बहुत पर्टिनेंट प्रमोद भैया, आई एम फुल्ली विथ योर साइड. आपने बहुत पर्टिनेंट क्वेश्चन रेज किया कि फॉर्म 3 के बाद में व्हाट नेक्स्ट. फॉर्म 4 फाइल करने के समय में you do not have any appeal withdrawal letter because there was no appeal pending.
अपील ही फाइल है.
तो जिनेश जैन जी जो बोल रहे थे, like I again the same stand कि there was no appeal pending as on 31st of January. So how do you file an appeal withdrawal letter? So therefore ये क्वेश्चन नंबर 67 है, उसका FAQ ऑटोमेटिकली जो है डिसमिस हो जा रहा है. मोदी जी, have you understood the question and answer?
I have understood. My point is appeal withdrawal appellant, मेरी अपील ही नहीं, मैं तो विन किया हूँ, तो मैं यहाँ पे विड्रॉल लेटर क्यों फाइल करूंगा?
नहीं, रेवेन्यू की अपील भी पेंडिंग नहीं है सर. देयर इज नो रेवेन्यू, बिकॉज़ रेवेन्यू तो क्या करता है, ऑलवेज कॉन्डोनेशन फाइल करके फाइल करता है ना, तो इसके फिर रेवेन्यू ने फाइल किया नहीं.
इसका अपील विड्रॉवल लेटर यदि करेगी तो रेवेन्यू करेगी, मैं क्यों करूंगा? वाई एम आई.
ठीक है, फॉर्म नंबर 4 के दिन जो है, फॉर्म नंबर 4 जो अपलोड करेंगे उसके पहले तो कम से कम अपील फाइल होना चाहिए, तब न किसी को अप्रोच करेंगे. सर आप एक तो फाइल कीजिए लेटर को और उसका कॉपी दीजिए हमको. आप किसको बोले? अपील ही नहीं फाइल है. फॉर्म नंबर 4 के दिन आपको होना चाहिए.
As a matter of fact, this question number 67 of FAQ, I think, is beyond the act passed by the parliament.
हाँ, अब क्या कि सुरेखा जी कुछ बोलना चाह रहे थे. सॉरी सुरेखा जी, मैं आपको डिस्टर्ब कर दिया, प्लीज आप अपना बात को रखें.
नहीं सर, अभी आपने जो कहा कि 67 बियॉन्ड द स्कोप ऑफ पार्लियामेंट, मैं एक चीज कहना चाहूंगा कि ये बियॉन्ड है या विदिन है, but since it is a benefit, if it acts as a beneficial provision for the applicant or for the appellant, I mean for the declarant, I mean I'll put it that way, then obviously it will be binding.
No, but it can be the other way around. No, it can be against the declarant also. The whole thing is
it can go other.
ये ना अभी कॉन्स्टिट्यूशनल वैलिडिटी की बात को छोड़ के अपने ये
कॉन्स्टिट्यूशनल की मैं बात नहीं कर रहा हूँ सर. मैं ये बोल रहा हूँ कि जो स्कीम इटसेल्फ जो पास हुआ है पार्लियामेंट में, उसमें ये कि 21 जनवरी को आइदर द अपील शुड बी पेंडिंग और द टाइम लिमिट शुड नॉट एक्सपायर. अगर क्वेश्चन नंबर 67 बोलता है नहीं, कंडोनेशन बाद में करके और डिपार्टमेंट बाद में अपील फाइल कर सकता है, वो एडमिट हो सकता है, तो आई फील दैट दिस इटसेल्फ इज वेरी चैलेंजेबल पॉइंट.
67 doesn't say so. 67 says that in case where the department is lost and if they have not filed even appeal, even then you can avail the scheme. Up question 67
I will add something that yes. It is not like that. Section 10 and 11 of the Act has given the power. Government has taken the power to relax some of the provisions.
Yes.
Relax some provision powers and issue
clarifications. The board has power to
and pass any order to remove the difficulties. So
yes,
that is not going to be challenged. That is very acceptable at all level.
Right, we have. So Sylvia, I also fully endorse your view here.
Yeah.
So I think, probably answer 67 of FAQ has a merit yes. In favor of Surekha ji. Probably it appears.
अगर 67 को थोड़ा सा एलाबोरेट करके यूटिलिटी में उनका जो फॉर्म 1 का यूटिलिटी में मॉडिफिकेशन हो जाए, तो वन कैन अवेल द स्कीम. अगर if you persuade them, if you request them or take up at a higher level, if they make a little modification in the utility and without appeal referenceable, the form is allowed to be filed.
मोदी सर, मैं इनकी बात को समराइज कर देता हूँ. क्या है कि यदि if there is no appeal pending and there is no appeal filed by the revenue, if you go for filing declaration form number 1 and 2, you have to
डिपार्टमेंट के
file.
माइंड में क्लैरिटी है
You have
कि
to
अगर
file a-
डिपार्टमेंट ने अपील नहीं फाइल किया है तो एसएससी कैन स्टिल अवेल द स्कीम 67 से ये क्लियर होता है. दिस हैज कम फॉर द फर्स्ट टाइम फ्रॉम द डिपार्टमेंट. डिपार्टमेंट के माइंड में ये है कि अगर डिपार्टमेंट ने अपील नहीं फाइल किया है और टाइम भी एक्सपायर हो गया है, वन कैन स्टिल अवेल द स्कीम. ये 67 से क्लियर होता है. Only thing is we have to request them to that form 1 has to be modified to that extent कि बिना अपील रेफरेंस के फॉर्म 1 एक्सेप्ट हो जाए.
बिना अपील रेफरेंस के फॉर्म 1 एक्सेप्ट नहीं हो रहा है एज ऑफ नाउ.
नहीं हो रहा है तो वो अपने को परसुएट करना पड़ेगा सर आपको अपने लेवल में, क्योंकि दैट इज द इंटेंशन ऑफ द क्लैरिफिकेशन 67 से ये क्लैरिटी हो रही है सर.
ओवर टू मोदी भैया.
नहीं भाई देखिए पॉइंट इनका मेरिट तो है, but the scheme seems to be, I mean, answer seems to be not in fully rhythm or in sync with the act or rules. So the point is correct, but then he has a merit. And if suppose he files form number 1, form number 3, form number 3 को जब वो respond कर रहे हैं, at that time he doesn't have any evidence of this withdrawal of appeal because no appeal have been filed by the department. I think probably he will go ahead with the form number, compliance with form number 3, and probably if the department reject it, he has a good case in the High Court. He can go by way of a writ. I mean, he can contest the matter by way of a writ. He will have a very strong case.
Form 1 accept नहीं होगा ना सर. Form 1 itself will not be accepted because no appeal reference is there. Form 1 itself will not be accepted.
Now, if Form 1 is not accepted, then again you will have a good case. You can go in for writ. कोठारी जी आपका क्या view है?
Answer to question number 67 is not about appeal. That earlier also I told. This is about prosecution. The question is whether in cases where the appellate authority has quashed the prosecution complaint or ruled in favor of the taxpayer and no further appeal is filed by the department on or before filing of the declaration are eligible. In that answer is yes. It is about prosecution.
We are discussing another question then.
Okay.
I think
supposing even okay, agreed, Kothari ji, very nice point out by you. I mean, we were assuming that it is including prosecution as well as other matters. But supposing this case arises, I mean, department has not filed an appeal. Can this particular case be not availing this VSVS?
Department has not filed appeal. We don't know that. But we can only estimate whether there is time available or not. We can mention that order was by the tribunal was pronounced on such and such date. And accordingly, from that date, so much time is available. And we have not received any notice of the appeal filed. But time is available.
Should I add something here? In that circular, earlier I also told, in that circular, if it has been allowed to file the VSVS scheme, file the appeal, even time has expired with condonation application, then till the date of circular, then one must check with the department whether they have filed the appeal or not. If they have not filed the appeal till the date of circular also, then you have a very strong case. That the department cannot go later on appeal and then they have himself come with this scheme and then again file the condonation application. Very strong case of the department.
Very correct. Then if the department later on goes, in appeal, then we have a very strong case. I mean, I was barred from.
Now the department has been given the time to file with the condonation till the date of circular.
Right. Very strong case. Very right, Diya. Very right.
In fact, in case of a matter lost by the department, if SSC want to pay tax, it must be willingly accepted. Whether department go into appeal or not, that should not be a criteria. For this, I think removal of difficulties can be a way in which we can seek a remedy from the central government. And I hope if a proper application is made, this will be allowed, that in case of appeal won by the department, SSC can pay to buy peace of mind, even if department intend to file appeal.
Actually, they are not applying the mind very accurately. At the beginning, you have said that they have done it half-heartedly.
The thing is very confusing.
Very confusing. And they could have done a very easy process so that everyone could have avoided. They have made it liberal in this letter FAQ. But again, they have left some lacuna somewhere, this and that.
For that, we must approach to the central government or the CBDT or the DG system also, principal DG. He can also prescribe for that. This can be tried through the my account grievances section. What is that called? Nivaran. In case of
E-Nivaran, that is called E-Nivaran.
Some solution can be given by the principal DGIT.
Anupji, I think we had enough discussion on VSBS now. Should we not switch to the second topic because it's only 2-hour session? So we are approaching the fag end. So should we not, should we not switch to the optional taxation scheme, tax rate?
No, Modi ji, I think that can be taken at some other time because material is there. There is not much urgency except in case of some companies who may adopt 22% rate.
सर आप थोड़ा बहुत हम लोग को हाईलाइट बता दीजिए ना, उसमें डिस्कशन हो जाएगी क्या है? आप उसको बड़े threadbare मत पढ़िए. You can simply highlight a few points.
In the notes I have highlighted, I think first let read it thoroughly again, and then we can have a deliberation on that issue. Because
सर हम लोग ये प्रोग्राम इसीलिए रखते हैं कि रीड नहीं करना पड़े. सर हम लोग डायरेक्ट मसाला चाहते हैं.
But it will not be justice with those provisions. They are also due. 115 BA is in force for 2 years. And I also need just let me see the file.
You can say in a broader way, Kothari ji, I mean, so that we can have a small interaction on that point also. I mean,
you can cover bullet points only.
You can cover bullet points instead of being very specific. I mean, what is
provisions which provide optional reduced rate of tax are with the disadvantage of foregoing all incentives under Chapter 6A, except Section 80 GGA and 80M, and all other deductions for income as referred into Part C of Chapter 6A. That those will not be available. Some weighted deductions and deductions under Section 35 will not be available. Initial depreciation will not be available. And carry forward of loss to the extent of initial depreciation will also not be allowed. These will be disabilities. Another disabilities is that if we adopt for a particular scheme, then we cannot go forego it. We have to continue, except in case of 115 BAA. If we lose that, we can come back to 115 BAA. Sorry, BAB. 1 minute. So the companies which have a definite source of income and not much plans of future for diversification of businesses where more incentives can be available under Income Tax Act, they can adopt to go for new options. These all sections are under Chapter 12. I am going by Section 115 BAA. This section starts with, here also drafting is confusing. The chapter is 12 of Income Tax Act, determination of tax in certain special cases. 115 BA, BAA and BAB are the 3 sections which provides options to the companies. The section starts with notwithstanding anything contained in this act, but subject to other provisions of this chapter, other than mentioned under section another 2 sections. In case of 100 BBA, BAA, it is 100 BA, 115 BA and 115 BAB. And likewise, in other provisions, the remaining 2 sections are appearing. Therefore, provision of Chapter 12, subject to some exceptions, will apply, and other provisions of the Act will not apply. The provision seems very confusing, involving many contingencies in near future and in long term. Also contingencies due to past assessment and disputes. Furthermore, every year there are changes in provisions and new incentives may be introduced. Therefore, decision to opt for any of new provision should be after very careful examination of facts and circumstances, disputes in earlier years, and expectations in medium to long term about plans of company have to be considered. It is also not clear about how the income will be computed so far allowable deductions are concerned. In computation, related provisions only what will not be allowed is provided, and for depreciation new prescription is to be provided. Recently, notification has been issued that if these options are exercised, depreciation in excess of 40% will not be allowed. Wherever there is higher depreciation is allowed, if an option is exercised, depreciation will be restricted to 40%. That is only the change about depreciation. The second provision in this category of new provision is section 115 BAA. That is reproduced in a document titled section 115 BAA, certain domestic companies with effect from 01/04/2020. From provisions with highlights, the tax on income of certain domestic companies. In this, my observation is that meaning of domestic company is very important. For that, I have given a separate note, and that will be an interesting issue for brainstorming. For section 115 BAA, the first assessment year can be 2021. That is the current year for which we are preparing returns. This section is optional. Rate of tax will be 22%.
कोठारी जी, हम लोग को लगता है कि अपने एकदम फैग एंड पर अब टाइम एकदम नहीं है, तो मोर और लेस ओवरऑल अब मिलकर किसी का यदि कोई एक आध क्वेश्चन है तो अपने इसमें ऐसे ब्रॉडर वे में ले लेते हैं। तो यदि आप अलाउ करें तो एक
इसके लिए मेरे ख्याल से मोदी जी पहले सबको स्टडी कर लेने दीजिए।
ओके
115 BAA जो है वो अभी डिसीजन लेने वाली चीज है, क्योंकि असेसमेंट ईयर 2021 का रिटर्न अभी फाइल करेंगे कंपनीज के लिए।
ओके
तो जिस कंपनी में कोई खास बेनिफिट नहीं है इंसेंटिव्स का, वो इस सेक्शन को एडॉप्ट कर सकती है।
सर मेरा एक तो क्वेरी था, मेरे क्लाइंट का, आई मीन वन ऑफ माय क्लाइंट हैज क्लेम्ड एडिशनल डेप्रिसिएशन इन द पास्ट इयर्स। अब एडिशनल डेप्रिसिएशन मेरा कोई कारण से मेरी इनकम नहीं थी तो वो एब्जॉर्ब नहीं हुआ, और वो डेप्रिसिएशन के माध्यम से कैरी फॉरवर्ड माने इज बीइंग कैरी फॉरवर्ड बाय थ्रू डेप्रिसिएशन। आपने जैसे शुरू में कहा था कि डेप्रिसिएशन बोल के अनअब्जॉर्ब्ड कुछ नहीं होता, तो एडिशनल डेप्रिसिएशन बोल के भी अनअब्जॉर्ब माने अनअब्जॉर्ब्ड एडिशनल डेप्रिसिएशन बोल के इनकम टैक्स में कोई कंसेप्ट नहीं है।
That forms part of current depreciation. If you consider
करें, अब इन्होंने कहा है कि जो नई स्कीम आप अडॉप्ट करेंगे, नई रेट कम रेट हम अडॉप्ट करेंगे, तो टू द एक्सटेंट माय अनअब्जॉर्ब्ड डेप्रिसिएशन रिलेट्स टू द एडिशनल डेप्रिसिएशन, द सेम विल बी डिसअलाउड। मेरा कहने का मतलब है अनअब्जॉर्ब्ड एडिशनल डेप्रिसिएशन बोल के तो कोई कंसेप्ट ही नहीं है, तो क्या डिसअलाउ होगा? तो मैं क्या
फॉर्मूला अप्लाई करना पड़ेगा, प्रोपोर्शनेटली लेना पड़ेगा।
नहीं, मैं क्या, मेरे को किसी ने, मैं किसी बॉम्बे से मैं ओपिनियन लिया था किसी एक टैक्स एक्सपर्ट का, उसने कहा कि ये बहुत इसमें स्ट्रॉन्ग पॉइंट है एंड दिस प्रोविजन विल बी चैलेंजेबल सो फार एज इट रिलेट्स टू द अनअब्जॉर्ब्ड डेप्रिसिएशन एडिशनल डेप्रिसिएशन, क्योंकि अनअब्जॉर्ब्ड एडिशनल डेप्रिसिएशन बोल के कोई है ही नहीं, वो अस्तित्व खो दिया। इट बिकम्स अ पार्ट ऑफ डेप्रिसिएशन एंड डेप्रिसिएशन इज फुली अलाउएबल। तो बोला यू हैव ए स्ट्रॉन्ग मेरिट, प्रोबेबली इट विल बी चैलेंज इन द कोर्ट ऑफ लॉ लेटर ऑन, एंड मैंने उसका तो कितना दम है इस ओपिनियन में?
नहीं, लिटिगेशन तो हो सकता है इस पर और जीत भी सकते हैं। मेरा तो व्यू ये है कि अनअब्जॉर्ब्ड डेप्रिसिएशन है नहीं कुछ, तो ईयर वाइज जो कंप्यूटेशन करते हैं दैट इज ओनली फॉर सम convenience of the department and SSC that we ascertain what was the situation in different years.
Right.
But all depreciation becomes part of the current depreciation.
Exactly.
Including initial depreciation. Right. And my view is that initial depreciation is not deductible from WDV because it is in nature of incentive. It is a one-time allowance allowed on cost, not from WDV. And it is as an incentive given for investment in new plant and machinery. Okay. Therefore, it should not be deducted from WDV. However, in the ITR form that is provided in the depreciation schedule, and it get reduced. Therefore, I suggest, and my clients are doing that, we are claiming initial depreciation otherwise than the depreciation schedule in computation part, and we are not deducting from WDV.
Okay.
that is real thing, that it is an incentive allowed for one time on the actual cost, whereas the depreciation is to be allowed on WDV from year to year, not in once in the life of the asset. And it is allowed for investment.
Okay.
So these controversies will arise, but how it is to be dealt in tax side report, that has to be decided by the tax auditor. If it can be part of other losses, then also it will lapse.
Right. So that was really fantastic. I mean, this particular analogy, the last point which you said, I mean, that is not part of WDV and it's an incentive. So it should not be reduced from W. That's really a fantastic planning, probably, a fantastic interpretation. Probably might lead to litigation, but then, well, we are here to tackle those litigations.
In one case, CIT appeal allowed this.
Okay.
And the substantial amount was there. 15 crore rupees was the initial depreciation. CIT appeal held that 20% will be allowed in the first year. At that time, there was no provision of 10% this year, 10% next year.
Okay.
20% will be allowed and it will not be deducted from WDV. And department did not take any ground against this. Though appeal was filed on other issues like carbon credit and other, some petty issues also department preferred appeal. But on this, no appeal was filed. That was not a case of Calcutta. That was case of some other jurisdiction. But appeal was not filed. Even during course of a hearing before tribunal, no ground was taken. And that has been given effect to by the AO and that is being followed. Initial depreciation is computed. Separately, it is claimed and it is not deducted from WDV.
So that clearly proves, Kothari ji, that your viewpoint have been in a way accepted by the department.
Yeah. But you see, it's a personal matter of particular SSC.
Yeah,
So
that is true. That
it
is
is
true.
the order of the CIT appeal, not of tribunal.
Yeah,
Had it
very correct.
gone to tribunal and tribunal allowed, I could have shared the order. But order of appeal, I will not share. But that
is true. That is confidentiality and privacy is one of the two important pillars of our practice. I fully agree.
Also, I am adopting the same practice. It is not deducted from WDV, and in tax side report, explanation is given with two judgments. And recently, Supreme Court has also held that nature is incentive. In case of IMDC, I think.
Yeah.
Was related to procedures, the Supreme Court held that initial depreciation is an incentive. It should be, provision should be interpreted in such a manner that the benefit is actually allowed and not denied.
Fabulous.
The nature of incentive is again recognized in these three sections. That it is, these are considered incentive and therefore they are denied. Normal depreciation is not denied. Other losses are not denied. Only the loss element of incentive provisions is being disallowed. So these are incentives. And an incentive being depreciation nature of initial, additional, extra shift allowance. These are not depreciation for wear and tear. These are not allowed on WDV from year to year. And they are different from depreciation.
Okay.
Another aspect
that
disturbing is required is given in the write-up about a domestic company. You see, tax is imposed on a domestic company. Domestic company is defined a company which has made arrangement for declaration and payment of dividend. If a company has not made any arrangement for declaration and payment of dividend, whether that is a domestic company within that meaning, if that is not a domestic company, the tax should not apply.
But sir, this definition of domestic company is since age long. I mean, it's a very age-old definition.
But on that, dispute has not been taken, and there is a wrong practice that language is used. See, just I'm
Sir, basic arrangement means, I mean, maintenance of the register, shareholders register. I mean, that is the meaning of this section. That the maintenance of the shareholders register and all these things.
Reading that meaning, it is meaning 222A of section 2. Domestic company means an Indian company or any other company which in respect of its income liable to tax under the Act has made the prescribed arrangements for declaration and payment within India of dividends, within bracket including dividend on preference shares, payable out of such income. That is the meaning of domestic company.
So what are those prescribed? Where it is prescribed? I mean, these are prescribed in the rules, no?
No.
I think I have read somewhere. I read somewhere that the shareholders register is properly maintained and all details are.
Not arrangement for declaration or payment of dividend.
Okay.
Maybe that prescribed. If a company has not declared dividend, has not made payment of dividend, whether this will apply. This matter was discussed initially by me with the senior consultants like great Sukumar Bhattacharya, great N.K. Poddar, and great K.V. Singh also.
Okay.
They told Kothari, to practice hamesha se chala aa raha hai.
Exactly, that's what I'm saying. It looks like it's an age-old concept, and nobody bothered to look into it.
In person. Therefore, a claim was not made.
Okay.
I raised this query in taxmanagementindia.com in discussion forum.
Okay.
People have looked at various.
Okay, Kothari, I think now is time. Anupji, do we have a time to extend the session, or do we pack up here?
I believe we should wrap up, Modi ji.
Yeah. So, Kothari ji, with your permission, can we wrap up? And if the members will have any query, we have already shared your mobile number and email address. So, if they have any query, they will probably write it straight to you. Or if the query comes to association, then association will forward the query to you for our members' enlightenment. Right? So,
I will have to read these things because I did not favor adopting this settlement.
Okay.
So, I will make effort to reply.
Okay, sure, sir. We are so obliged. Yes,
and we must approach to the government, Central Board of Directors, Taxes and Finance Minister to resolve these difficulties, particularly in relation to departmental appeal.
Okay.
हम लोगों का क्या कसूर है, हम लोगों की क्या गलती और हम लोगों की क्या कमी है कि हम टैक्स देना चाह रहे दे नहीं पा रहे.
सही बोल रहे हैं कोठारी जी. हमारे प्रेसिडेंट साहब इस सेशन को पूरा सुने हैं. So I think he has noted all these suggestions which have come from you and from other members, and certainly the association will take a lead role in forwarding these queries and questions to the security.
For 264, if time is available, it must be allowed.
Okay.
The provision is that 264 filed will be eligible.
Okay.
If time is available, that should also be allowed.
Okay, keeping in spirit the other. Yeah, you are very right. So Anupji, I mean, vote of thanks कौन देंगे थोड़ा देखिए जैसे आगे का formality.
First of all, let me brief or let me convey to all our delegates and participants. Our learned speaker, CA Dev Kumar Kothari ji, has shared with us a very detailed and beautiful write-up on today's deliberations on both the topics, on Vivad se Vishwas scheme as well as the that new provisions of the laws. So this detailed write-up will be shared with all the participants over the mail, as well as the same will be placed, put up in our ACA's website. I have given the website address also, and simultaneously the same will be mailed to all our 1300 plus members across. So thank you very much, Kothari ji, for sharing your write-up. And I must thank our Direct Tax Subcommittee Chairman, CA Ramratanji Modi, our own Ramratanji Modi, who happened to be our past president of ACAE, for moderating the entire session so nicely, for taking up the questions for the benefit of our members, as well as interacting with our couple of senior professionals like Sushil Pransukha ji, Pramod Himbasrika ji. So many thanks, Modi ji, for very, very nicely moderating the entire session. We are indeed thankful to you. We are just sharing a small memento as a token of love from ACA. Could you able to see this memento, Modi ji?
Yeah, fantastic, fabulous, so nice of you. What a nice gesture. Thank you so much, Anup ji.
Thank you, Modi ji. My thanks goes to our learned speaker for today, CA Dev Kumar Kothari. I was actually eagerly, anxiously waiting to hear you out, Kothari ji. I have heard you I have heard a lot of informations about you. You have spoke in this fora earlier also. I have read couple of articles in ACA Journal, which previously you have written. I was a General Committee Chairman in the year 2016 while Modi ji was president, and you shared an article. I still remember that it was still a memento, or it is kept in my archives, and I am still reading and being cherished with those memories. Kothari ji, you shared your deliberations today. You accepted our request for joining these deliberations. Many thanks on behalf of ACA for the entire delegates out here. ACA and its members, really thanks to you, Kothari ji, for deliberating on a very important topic, and that too in an interactive mode. ACA is really thankful for this. On behalf of ACA, we'll be sharing a e-memento with you. So this is an e-memento for you, and the physical copy will be reaching to you either by courier, or our ACA office staff will send you this physical copy. Since you spoke after such a long time, so we will also be cherishing your memory of these deliberations with you, sir.
I am glad.
My thanks goes to each and every participant here who has made this session very, very lively and made it interactive. Participants, your question and answer only makes any sessions great. And please keep on asking questions. Please keep on joining ACA's session. We have another session on forensic accounting and auditing on 12th of December this month, Saturday from 5 to 8. And speakers across India will be joining that session. Thank you very much, each and every participant. Many thanks. And with permission of our Directors Committee Chairman, if he permits, then I'll close this session.
Yes, sir. Yes, Anupji.
Okay. Thank you very much.
Thank you very much, Anupji. Thank you very much, Kothari ji also, and all participants.
Well,
thanks to each and every participant. Thanks to joiners, Pramod Himmatninka ji. Thanks to Sushil Prantuka ji. Thanks Dinesh Jain ji. Thanks to each one of you for raising your queries and making the session lively. Many thanks. Kothari ji, thanks once again, and looking forward to you in our future program.
Keep yourself in house as much as possible at home and work from home.
Thanks a lot, sir.
Work from home for last 30 years. 95% work is from home. Only for appearance, I go out.
Okay, yeah, that's great. That's great.
If for client from Calcutta or elsewhere, they need not to come to me. Work is done smoothly.
Kothari ji, एक छोटी सी request है. Our participants and delegates, they may have some questions on Vivad Se Vishwas. With your permission, if we'll compile all the questions, then if you permit us, then mail it to you.
Sure.
Okay. Thank you very much, sir. Thank you very much. Thanks, Modi ji. Thanks, Modi ji, for moderating the session. Thanks to each one of you. I am closing the session.